My case is set for preliminary hearing, and I'm not even ready to have to take the stand yet. What am I supposed to do? What do I tell my lawyer? All right, guys, this is Lee Berlin, Oklahoma's only attorney dedicated exclusively to defending individuals charged with special victim cases, sex crimes, and domestic assault and battery. And in my cases, the vast majority of those cases end up getting set for preliminary hearing, and we end up having the preliminary hearing. And what is the preliminary hearing? The preliminary hearing, if your attorney hasn't told you, or if you're just new to this process, is really the first time that the state of Oklahoma's evidence gets tested in the process. So instead of us going to a grand jury, the state of Oklahoma files a charging document called a felony information, and that initiates the process. Warrants go out and the whole criminal justice system all churns up to try to get you into the zone of guilt. And what we're trying to do here with the preliminary hearing is require the state of Oklahoma to prove that a crime was committed and that more likely than not, you committed that crime. And to do so, the entire burden of proof and persuasion is on the state of Oklahoma to prove a very low burden, okay? Just tipping the scales, okay? That a crime was committed and more likely than not you committed the crime, and they do that through presenting evidence at the preliminary hearing. So they're gonna call witnesses. They are gonna call witnesses, and they're gonna put witnesses on the stand. And when they're done with each witness, then I'm gonna get up there and cross-examine that witness. When they're done with witnesses, okay, we don't put witnesses on. You will not take the stand at the preliminary hearing. You will not have a speaking role at the preliminary hearing. There is nothing that you need to learn or study or examine. It is an opportunity for you to listen and hear the evidence against you, test the evidence against you, and to fix the state in their position for all of time. Okay? It is not one where you will be called to the stand by the state of Oklahoma. All of your anxiety, all your fears and worries about what's going to happen there at the preliminary hearing really lie upon your attorney. So when my clients go to a preliminary hearing, they know that they're not going to take the stand. They have a legal pad and a pen, and they understand that they are to listen and take notes. And they don't have an active role. Now, of course, we ask the client before we're done with any particular witness if they have any questions or things that we need to expound upon about. But that places no burden or obligation upon the client to do anything. Now, if they have a question or concern, they of course will let me know. And I may choose to include that in the questioning, or we might reserve it. The reason being that we might not want to forecast our particular position or question series. Maybe we've set the witness up perfectly for where we want them, and you want for trial. And now you want me to ask the $64,000 question that won't move the judge at preliminary hearing to change their mind about whether the case proceeds, but would make all the difference in the world at trial. So there's a lot of reasons why we may ask the question, or that we may choose not to ask that question, but your role and your participation in that is as limited as you want it to be, or as broad. So if you've got 5 or 6 areas that you want me to talk about, you can show them to me, and I may choose to include them in questioning at the end of my examination of that particular witness or not. But your role as far as taking the stand and having to go up there and swear to tell the truth, the whole truth, and nothing but the truth, that ain't gonna happen on our watch at the preliminary hearing, right? So don't worry about having a speaking role, okay? Relax, all the stress is on your lawyer. Until the next one.